All right, welcome everybody. What we're doing is uh, having a quick review of class three. Unfortunately, my attempt to record the class last Wednesday failed again for whatever reason. So I'm offering this review of our third class for those that may have missed it or wanted to go back over it. Um, and so this will be just kind of a quick 30-minute review or around 30 minutes of reviewing the things that we talked about in class three, which also included a review of class two as well. Um, so let's get right to it. Um, our reading assignment for this week was Comcast versus the National Association of African Owned Media, also known as the Byron Allen case. We're going to talk about that as it extends from our discussion last week about how the law thinks in terms of text, intent, purpose, and modern dynamics, right? Four tools of statutory interpretation. And then hopefully by the end, we can talk about the Racial Licensing Preference Act by Derek Bell. Um, Again, it's a very good response to Comcast versus NAAAOM. Unfortunately, we didn't get to talk about it a lot in this class, and we'll actually start our conversation in class four off with Derek Bell's Racial Licensing Preferences Act. Just as a reminder, we went in our progression to this point started with week one, our readings. I got to know you. You guys got to know me a little bit. But as far as our readings are concerned, we started with the foreword of Derek Bell's Faces at the Bottom of the Well, written by Michelle Alexander, who's the author of The New Jim Crow, which is probably the most popular critical race theory book of the 21st century. She was a student of Derek Bell's and also a adherent to what Derek Bell would call racial realism, but Black philosophers today may call Afro pessimism, which they believe in the extension from Derek Bell's work. I think it is an extension. I don't think it perfectly represents Derek Bell's work, and we're going to talk. We've talked about that. Derek Bell introducing divining our racial themes, and also Kiara Bridges, chapter one, The Origins of Critical Race Theory. It's starting in the 70s, growing in the 80s, breaking out, even out to the rest of the whole country and all law schools in the 90s, becoming interdisciplinary and even international in the 2000s, to the point where now, 2010 to 2020, some may even complain that it's so large that it's formless, right? So just as hip hop and critical race theory, what is its definition? We talk about hip hop, we talk about critical race theory, but it's very hard, even for those that perform it, to actually give a particular definition. And we're going to talk about that in week four as far as the criticisms of critical race theory. All right. Now, the next week, we took 2 weeks, and after the inauguration, we discussed some of the terminology that Kiara Bridges uses when she talks about conservatism, liberalism, neoliberalism, and then also progressivism, and where critical race theory fits with that. Again, in the end, much of what we're doing is trying to influence the law, which means also means influencing judges. So we related those terms conservative to the conservative justices on the court, on the Supreme Court. We also attached the term conservative to the idea of protecting property, as in life, liberty, and property, a concentration on property, where liberal would be the Democratic appointed judges on the Supreme Court, Kagan, Sotomayor, and Breyer. And we attach that sort of to liberty, right? Life, liberty, and property. So conservatives seem to focus a lot more on property, whereas Democrats more on liberty, and the discontent from the progressive side, and which also sometimes we can maybe sometimes equate critical theory with the progressive side, or at least Professor Bridges does, or seems to, that the government is responsible for life, right? So more than just protecting property, more than just protecting liberty, that it should have a more active role in protecting and in advancing each one's the pursuit of happiness, the idea of positive rights in the Constitution instead of so-called a constitution based on negative rights. Negative rights being the government can't do this. Progressives seem to argue for the government to do things, right? So positive versus negative rights. Um, we finished that off with Derek Bell, the Afro-Atlantica Awakening. As Professor Bridges describes Derek Bell's philosophy, she says that he's more conservative or has a conservative approach. I may disagree with that. However, I do believe that what she means is Derek Bell is more concerned with material benefits, the way which the law either subordinates or discriminates or even supports Black people materially. So again, so a reference to property, if that's what she means by conservative, then I guess I could agree there. Um, his Afro-Atlantica Awakening, that chapter 2, very interesting about, again, the difference, Black people not being a monolith and separatism versus staying, then the idea of whether we should go. Again, there are white folks not being a monolith, some preferring Black people to leave. On the other hand, some preferring the Black people to stay. Um, and what I took from Afro-Atlantica, this mythical island that appears in the middle of the ocean but disappears, is what is the law then? As a critical race theorist, we talk about the ways in which the law subordinates. We talk about the way pretext is used. We talk about systems and justice and fairness. The question becomes, if Afro-Atlantica would have stayed afloat, if it would have stayed a viable place where only Black people, for whatever reason, can breathe, the question becomes, what is the correct or the just legal architecture? How do we take what the criticism of the system we have and convert it into something that actually does in fact produce meritocracy, if that's what we're after? All right, so then so we talked about conservative versus liberal discourse. We talked about what do Michelle Alexander Derek Bell mean by racial realism. Again, the idea that racism is permanent. What does that mean? Does it mean everybody's racist? Not necessarily. Some people can interpret it that way. However, I think the most productive way to understand racial realism is to equate it, racism, whatever that means, because we're going to talk about what does it specifically mean to be racist or what is racism. But whatever it is, the argument is that, like crime, like greed, right? These are sins that you always, in fact, deal with. You create laws. You promote. You establish government programs to minimize or restrain greed, to deal with crime, without believing that you're ever going to eliminate it entirely, right? In the sense that racism is permanent, just as sin, as greed or crime is permanent. That's the way I interpret it. There are other ways to interpret that, and we can talk about that in future classes. Again, we talked about the origins and chronology of CRT. We talked about what is critical race theory. What does it mean to be critical? I just discovered, I'm reading a paper right now by Neil Buchanan and Michael Dorf. It perfectly describes critical legal studies, right? A tale of two formalisms, how law and economics mirrors originalism and textualism. A great paper, very advanced. You're not expected to just pull it, read it, and understand it or what have you. If you are at an advanced level, however, this is the paper that was just published in 2020 for you, as far as trying to prove that conservative appeals to neutrality, objectivity through originalism and textualism are false, and that they just hide people's political ideologies. Okay, so that is what it technically means to be critical. However, critical race theory separates from critical legal studies in the sense that it identifies a power base that the pretext is serving. So elite whites or white supremacy or white male supremacy or white male hetero supremacy, depends on your construction of CRT. But the difference between critical legal studies and CRT is critical legal studies argues that there is a pretext that judges do what they want to do. They have normative, so-called normative priors, and the opinion writing process is very pretextual. It's a way to sell your opinion. How and the distinct difference between that and critical race theory is critical race theory tends to agree with that assessment. However, it also identifies more specifically that the power base that is being served by pretext uh, 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 is in service of racism or white supremacy, white male supremacy, hetero supremacy, however you want to discuss it. Again, that's not all critical race theorists, but as a general description, I think that works. Uh, is it critical? Is it race? Is it a theory? Right? A lot of critics will say neither critical, neither a theory. We're going to discuss that this Wednesday in class 4. That led us to discussion about the formal way the law does think. If critical legal studies criticizes the opinion writing process, if it criticizes the way in which judges say they write opinions versus the way they actually do, well, what is the way that judges say they do? What is the game that the critics are complaining about? And this is how the law thinks, right? In terms of formalism and realism, right? Formalism, there's a formalist camp, there's a realist camp, there's also a critical camp. Within the formalist camp, formalism deals with meaning, deals with correctness, deals with structure, right? So originalism is a formalistic context, all right? And we can kind of use two components to describe originalism. Textualism, and textualism relates to the meaning of a word as the audience hears it. Intent is the meaning of the word as a speaker intended it, right? So they both focus on the meaning of the word. If we use no vehicles in the park and we had a dispute as to what exactly is a vehicle, is a Segway that's supercharged or a wheelchair that goes 30 miles an hour that's carbon powered, is that wheelchair that's used by a elderly or disabled person, is that a vehicle in the park such that it should get a ticket, a fine? Is that what people understand vehicle to mean, right? Is that within that rubric, or did the original authors of the law intend to include vehicles such as that? What form was imagined? What meaning, right? Versus realism. The realist camp asked a different question, right? They asked, what are the consequences of finding that a wheelchair that goes 35 miles an hour, if that type of thing is a vehicle, does that promote or avoid the consequences the authors or the legislature intended to produce, right? So meaning, consequences, purpose and intent, right? We know that intent and purposes are linked together, right? For all intents and purposes. Well, the distinction is intent deals with meaning, purpose deals with consequences. What are the consequences that the legislature expected when it wrote no vehicles in the park? Did they expect to avoid physical injuries? Did they expect to avoid noise pollution, air pollution, sound pollution? Because if we know what the purpose was, then perhaps we can better evaluate whether that wheelchair that goes 35 miles an hour deserves to have a ticket. If the purpose was to avoid air pollution or sound pollution, and it doesn't create any noise or create any exhaust, then perhaps it doesn't serve the legislature's purpose to give it a ticket, and we're extracting property from a citizen for what reason, right? Dynamism is also part of the realist camp. However, dynamism deals with consequences untethered to legislative expectations. So if you were to say we shouldn't give that person a ticket because that would be too harsh on the elderly, right? That whether that the victim, the defendant being elderly, has nothing to do with the meaning of vehicle, either as is heard or as is intended. It has nothing to do with the purposes that I had identified a second ago for why the law might have been created. It is just one of the consequences a judge thinks perhaps should be important. Maybe that the legislature thinks should be important, or that the people should be think important, that these purposes are reasonable. Now, some people will call this purposivism. There's lots of different ways to describe all of these things, but these four ways: text, intent, purpose, dynamics. Those are the four major ways the law thinks. The meaning of words as understood by the audience or the listener, the meaning of words as understood by the speaker, the consequences, uh, um, the consequences intended or expected by the legislature, and the consequences or the policies that are in effect that are not necessarily anticipated by the legislature. Some people call this or judicial activism. William Eskridge calls this dynamism. Some people even call it purposivism off of Aaron Barak, but we're not going to go into all that right now. So again, no vehicles in the park. Text, the meaning of vehicles understood by the listener. Intent, the meaning of vehicles understood by the author. Purpose, the consequence the author intended to avoid or promote when outlawing vehicles. Modern dynamics, other important consequences other tethered to author's expectation when outlawing vehicles. Okay, so all of that, that's where we left off in class 2, which led us to class 3 in talking about Comcast versus the National Association of African American owned media. So can we apply those principles of text, intent, purpose, and dynamism to the Byron Allen case? Now, I've mentioned that the Supreme Court, let me go back. Every member of the Supreme Court believes text is important. Most of the judges of the Supreme Court believe intent is important, but not all. So even amongst the conservatives, it is Justice Clarence Thomas who is a very strict textualist and does not believe there is a such thing as an intent. However, some of the other judges are not as strident, or sometimes what I call chauvinistic. Intent, purpose, those things are more so attuned to or ascribed to the liberal justices. Breyer, Kagan, Sotomayor. Breyer wrote a book called Active Liberty, where he talked about the Constitution is intended to promote a broader, wider participatory democracy. Right? He wants to interpret it to promote good consequences. And in modern dynamics, other important consequences: no judge admits, no Supreme Court judge admits to being a dynamist. The closest you can get to it is perhaps Judge Posner, the retired conservative judge who argued for the consideration of economics or efficiency or national wealth maximization as something to be concerned about in practically any case a judge feels that it's appropriate. Right? Judge Posner is probably the highest ranking conservative dynamist who actually became the chief judge of the Seventh Circuit Court of Appeals. William Eskridge, the leading dynamist, is not a judge at all. Okay, so in the Comcast case, for those that were unaware of it, Byron Allen was a former comedian and entertainer who then became a media mogul that owns several channels, cable channels. He tried to get them on Comcast to distribute them. He claims they made him jump through all types of hoops. They led him astray. They led him along, but they never had really any intention of contracting with him. Because he was African American. He believes he has some type of evidence where there was some admission or declaration by a Comcast official that they were not trying to create a more Oprah Winfrey's or something to that effect. The Ninth Circuit held that Byron Allen at the pleading stage only needed to show that race was a motivating factor. a motivating factor in the decision not to give him a contract. Whereas Comcast argued that the correct standard was that he would have gotten the contract but for race. Two different standards: but for standard, motivating factor standard. What is the difference between the two? The but for standard is the one we use in torts, right? If you, for those law students, you've had tort class, so you know that when it comes to negligence, when it comes to other tort-like conditions, I have to prove that you were the reason why I was harmed, right? There may be, if you were just one of contributing factors, one of numerous contributing factors, but I would have gotten hurt without you, or I wouldn't have got, then I don't win. I have to find that you were that, but for your actions, I would not have been harmed. So that means that in this instance, that race had to be the criterion that caused him not to get the contract, where the motivating factors test says that if race is any part of the consideration at all, then the defendant should be sanctioned, right? It is a means of getting racist people out of the economy, right? That betters the economy, right? Under the employment context, we all agree. Congress wrote into the statute that if race is a motivating factor in the consideration over employment, that's all you have to prove, and you win. You are a private attorney for the general, general for the country. You have done the country a service, even if you wouldn't have necessarily been the number one candidate for the job, but you did find evidence that race was a factor. That's motivating factors test. So the argument that Comcast is making is that even if they did consider race, even if there was some racist statements made, even if there was some animus towards race, Byron Allen and any other black person in any other setting, right? Because this covers all commercial, more or less all contractual settings, that you have to prove not just that race was a factor, that you were hated or whatnot, but that it was the factor that kept you from getting the contract. So I will say, so let's even try to, I want to offer you a grid. So we talked about what happens if someone were to put together a grid to evaluate subcontractors that are bidding for an opportunity to work for my company, right? And let's say these subcontractors offer bids that they can do the work within this amount of time and it'll cost this much. And I have a grid that I'm evaluating each of these contractors by. For experience is one factor, cost is a factor, reputation is a factor. But let's say I also put in race as a factor. And I give demerits for one particular race, I get pluses for a different type of race. Under the motivating factors test, a plaintiff that discovers that that test is even being used will win, right? That the grid reveals that race was a motivating factor in the decision-making process. But they do not win if it is for the but-for test, because even if you would have gotten 2 points for a 2-point demerit for your race, if you lost the bid by quote unquote 7 points, then you wouldn't have won that bid even if you were white. So the fact that the defendant is racist would not matter under the but-for test, so long as he is also hiring a very well qualified white person, right, or whatnot. So the fact that he put the hamstrings on you or demerits for race, only person that can sue is the person who can prove that they were absolutely, without question, the top candidate for the gig without any, totally objectively. So that is a very, very high standard. And so if we look at the text of the statute, we're talking section 1981. All persons within the jurisdiction shall have the right in every state and territory to make and enforce contracts to sue, be parties, give evidence, and to the full equal benefit of all laws and proceedings for the security of person's property as is enjoyed by white citizens. I make the argument that in text, if the court is saying that they are textualists, that if we are looking at the plain meaning of the law, how can we say that a company that uses a grid that 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 demerits a contractor for their race has been treated as white citizens, that they have been given the right to make and enforce contracts as is enjoyed by white citizens, right? There's demerits for their race. So that that would mean that the motivating factors test is more appropriate, right? That if a bidder had assigned demerits for their race, if that was a motivating factor in the decision, that person was not treated in the same way to make and enforce contracts as is enjoyed by white citizens. So seems like a very easy case to me. Also, for different reasons, the Ninth Circuit held in Byron Allen's favor. Well, the court says, and let's talk about what would be produced. What is the importance of a decision either way? If we lower the standard, if we use the motivating factors test, then that is a step towards anti-racism. American University has declared itself in favor of anti-racism. And so to interpret Section 1981 as to promote private attorney generals in the nation to out racist, inefficient, and immoral business practices so that those folks can get sanctioned, that would be the motivating factors. The motivating factors test would be appropriate for that. On the other hand, the but-for test, where it sets the evidentiary bar so high that most people who are discriminated against can't even prove it, that reinforces the illusion of inclusion. So is the court's job to sanction only the most embarrassing and obvious cases, right? To promote the idea that America is a meritocracy, or is it to actually deter future racist behavior, right? I also, for those that are old school movie fans, look at the movie Trading Places and the evidence that Eddie Murphy had to get to show that he was about to be fired for his race. Is that the evidentiary standard, right? That he had to hide in a bathroom stall to catch the owners of the company saying something so blatantly racist and specifically in regards to his employment. That just seems like a very high standard. And I just want to take this time, for those who do not know, Washington versus Davis, the Supreme Court already wrote that statistics alone, right, disparate effects and whatnot are not sufficient to prove racist intent. So that's what the court was faced with. Do we go with the but-for test, the higher standard, and make it hard for people to sue, or you give it the lower standard as an as a nod to anti-racism and ridding the country of racist, inefficient market actors and push us greater towards meritocracy? Well, the Gorsuch believes he's a textualist, and the opinion was agreed to unanimously. He speaks of how the plain meaning of the test obviously includes but for, and there's no beef with that. No one argues that if you are in fact discriminated against by your race, and you can prove that that's the reason why you didn't get the contract, but for their racism, obviously that should be sanctionable. But the question is whether it also includes motivating factors. So the fact that it includes the but-for test, which Gorsuch spends so much time on, nobody disputes that. He's spending so much time beating down an argument that nobody's ever made, right? Everybody agrees that but-for is included with it, but is it broad enough to include the motivating factors test? And that's why we all ask about the grid. Under a but-for test, if an auctioneer excludes black bidders, can anyone but the richest black person in town or at the auction, file a suit, because how can you prove that you would have won the auction if you weren't the richest person in the room? Can you win if you're not the richest of all the bidders? Even if I were the richest of all the bidders, can I prove beyond a shadow of a doubt, clear and convincing evidence, that I had a greater desire for the item than anyone else, right? Or is the auctioneer allowed to exclude me from the bidding practice so long as he doesn't say out loud, I'm excluding all Black people from the bidding process, especially those who I think could win? Nobody's going to ever say that, right? All right. Textualism isn't just about plain meaning. Uh, when the plain meaning is unclear, textualists also try to see what is consistent with related statutes. They had the choice of interpreting Section 1981 the same as Section 1983, which used motivating factors, or they could interpret the same as Section 1982 that uses the but-for standard. The but-for standard was a product of judicial interpretation of 1982. The motivating factors test was put in there by Congress. It was statutorily declared. The Ninth Circuit believed that motivating factors, there's no reason to not expand the motivating factors test to all sections of the Civil Rights Act. However, the court here in Comcast's the Byron Allen case opted for 1982, that because of the court's convenience, right? Because this is the way the court does it, that they're going to stick to the but-for test, which is very interesting to me, because that doesn't, I'm going to explain to you in a second why I don't believe that's textualism. So that is a reference to text. We could also make the argument, and textualists do this, is the most obvious reading of a text is not only what we think the audience understands, but also the best evidence of what the legislature intended, right? So that's how they kind of are, that formalism, originalism, and textualism work together. They try to make it that they're indistinguishable. There are definitely distinctions between them, but they collapse into this formalistic project where text and intent are arguably the same. But so let's flip over to Ruth Bader Ginsburg's concurrence, where we can see appeals to purpose, right? Her appeal to purpose, first of all, let's look at what evidence she uses to prove the intent or purposes of the 1866 legislature, and what does she say about legislatures after 1866, right? Where does she find these purposes? In the legislative history of the act, in the judicial opinions of the court that have been either accepted or even overturned by the legislature. She makes a very big deal about how decisions made by the Supreme Court that limited the law in the past were overturned and expanded by Congress several times, arguing that that Congress is not only in 1866, but also later Congresses expected that the statute would produce less racism. Let's look at what she writes. I write separately to resist Comcast's attempt to cabin a sweeping law designed, right, that's a word for expectation or purpose, designed to break down all discrimination between Black men and white men regarding basic civil rights. It is impossible that a law intended to secure practical freedom, right? That's what it's a consequence, not the meaning or the form, but the consequence that they're trying to produce by the law, right, is to secure practical freedom, would condone discriminatory barriers to contract formation, right? So these are, she writes, the Comcast free frame approach to 1981 invites the court to repeat an error it has committed before, right? Right. She notes that in 1989, the court was slammed by Congress. They promptly repudiated that interpretation, arguing that the legislature intends for this statute to be interpreted broadly, right? She also mentions the different hoops that that Comcast made Byron Allen jump through. So these are the reasons why we can. This is how we're going to apply. We look at text, we intent, the purpose of the laws. Well, what about modern dynamics? What about consequences that that Congress did not identify? Gorsuch says he doesn't look at that. Justice Ginsburg, even though she's on the liberal side, she doesn't look at. She makes sure she talks about consequences only as tethered to previous Congresses, the original Congress that wrote the law, the Congress in 1989 that repudiated the 1981 interpretation. But think about this. Gorsuch, when he writes that opinion, he says he doesn't look for Section 1981 to determine what it means plainly to the average citizen. He asks whether or not it is written in a way that should upset the court's presumption of a but-for test. The court's own presumption, its own convenience, right? So the court has a way of doing things, and the question on the floor for Gorsuch is whether or not the text of the statute is important enough to trump their own concerns. I argue that that's judicial activism. I argue that that's dynamism. And so that is how a critical theorist works, right? This article, the opinion is written in a way to satisfy originalism. It's a way to satisfy textualism. Even Ruth Bader Ginsburg in her concurrence follows the rules as a purpose of this. There's rules to her game, right? And how she can come up with these different consequences. But as a critical theorist, our job is not just necessarily to say, I disagree with the opinion, but also to show you that the authors of the opinion have written something inconsistent with their own theory in order to come up with the judgment that they did. That if they had followed their own stated theory of textualism, the result would have gone in Byron Allen's way. And more to the point of critical race theory, a theory is supposed to be able to predict something, right? It's supposed to accurately describe something. It's supposed to predict what happens in the future. And Derek Bell's interest convergence theory predicted that Comcast versus NAAOM would use the but-for test, while Section 1983 would use the motivating factors test. Why? It is not in the interest of elite whites to use a loose standard in contracting, because that lowers corporate expenses and that increases competition for the capital class. Where a lower standard, the motivating factors test in the employment context expands the labor pool. And that wider, greater labor pool actually tends to suppress wages. So it's more fair as far as bringing in more blacks, women, foreigners, etc. However, the more eligible laborers there are, then that that pressure in the supply and demand curve allows employers to pick and choose, and then keep wages therefore low and productivity higher. So Derek Bell's interest convergence theory also predicts that this would be the result, right? That elite whites would prefer the illusion of inclusion, to have the statute on the books, for it to look as if we are not a racist country, and to be able to point to these laws to say so. However, to have them interpreted in a way where racism still continues to flourish, at least as far as the capital class is concerned. We did not get a chance to speak too much about racial realism and the Racial Preference Licensing Act. So I'm just going to talk about this real quickly, because that's going to lead off our discussion on Wednesday, which happens to be tomorrow. If racism is permanent, if it is always going to happen, like crime or let's say pollution, should we deal with it differently? It's not a saying that racism is permanent is not a way to just give up. He's asking that perhaps we take a different approach if it is permanent. Should those who choose to be racist perhaps instead of pretending and using pretext and hiding, shouldn't we just allow it and let them buy a license to do so and use the money for those those licenses to help out historically black colleges, right? So we're going to leave off with that question. Is it better to try to keep winning lawsuits where only Byron Allen gets the benefit if he wins? On the other hand, the likelihood of winning is very small versus a licensing regime where we allow people to be racist so long as they put money in the kitty that goes to the elevation of black human, social, political, financial capital as far as education or whatever the case may be. We can extend this to other. We could expand this to others. Should we have a gender preference licensing act? So I'm going to stop there. We're going to talk about those things in class 4. Hope you enjoyed this review, and I will see you guys tomorrow, 8 o'clock to 9:50. Thank you for listening.